Hello, everyone, and welcome to Uncivil Law. For today's case, we are reviewing a Supreme Court case that deals with a person who was abused by the police. This is the case of City of Los Angeles versus Lyons. So we're going to read this case and see what it has to say about issues that might be relevant to today's world. So let's get started with this. Lyons' complaint alleged that at least 2 deaths has occurred as a result of application of chokeholds by the police. His First Amendment complaint alleged that 10 chokehold related deaths had occurred. By May of 1982, there had been 5 more such deaths. On May 6, 1982, the chief of police in Los Angeles prohibited the use of a bar arm chokehold in any circumstance. A few days later, on May 12, 1982, the Board of Police Commissioners imposed a 6-month moratorium on the use of a carotid artery chokehold except under circumstances where deadly force is authorized. In his brief and at oral argument, Lyons reasserts his position that in light of changed circumstances, an injunctive decree is now unnecessary because he's no longer subject to a threat of injury. He urges that the preliminary injunction should be vacated. The city, on the other hand, while acknowledging subsequent events have significantly changed the posture of this case, again asserts the case is not moot because the moratorium is not permanent and may be lifted at any time. We agree with the city that the case is not moot, since the moratorium by its terms is not permanent. Intervening events have not irrevocably eradicated the effects of the alleged violation. We nevertheless hold, for another reason, the federal courts are without jurisdiction to entertain the claim for injunctive relief. So originally, there was an injunction that prohibited the courts from, or prohibited the police from issuing certain things. And then they put in place a moratorium. And then the guy said, well, I no longer have a case. But the government said, well, we could withdraw it at any time. So you still have a case. We want a decision. And which is a little bit unusual. You'd expect it the other way around, but that's what happened. So in any case, they said, well, it's not moot, but we shouldn't grant the injunction. All right, so why shouldn't we grant the injunction? Let's read on. No extension of our case law is necessary to hold that the respondent, Lyons, has failed to demonstrate or case or controversy with the city would justify the equitable relief sought. Lyons standing to seek an injunction requested depended on whether he was likely to suffer a future injury from these chokehold by police officers. That is one of the standards for injunction, likelihood of injury in the future. Count 5 of complaint of the alleged traffic stop and choking incident 5 months before, that Lyons may have been illegally choked by the police on one such occasion, while presumably affording Lyons to claim damages against those officers and immediately, and perhaps against the city. Yeah, we won't talk about qualified immunity right now, but yes, in theory, yes. It does nothing to establish a real and immediate threat that he would be stopped again for a traffic violation or any other offense by officer or officers who would illegally choke him unconscious without provocation or resistance. So they're saying it's unduly speculative going into the future. Right? Whatever might have happened to you in the past, you can get relief for that. Now, we're not going to really mention the whole 1983 issue and qualified immunity, but yeah, you can get relief for that. But going forward, we don't have any evidence that in the future you're going to be choked out for no reason. So it's too speculative. As far as an injunction goes, I agree with this on a long-term basis. Right? It's too speculative in the long term that we know we're going to be choked out. So yeah, there is a bit of a problem there. Again, injunctions are equitable and they're never afforded as a matter of right. And so there are some different prudential reasons for this decision. In order to establish an actual controversy in this case, Lyons would not only have to allege that another encounter with the police, but also have to make an incredible assertion that all police officers in Los Angeles always choke a citizen with whom they happen to have an encounter, whether for the purpose of issuing an arrest, issuing a citation, or questioning, or that the city ordered or authorized police to act in such a manner. So yeah, that is one of the problems here, that you're looking for something a little bit more definitive. So unless it happens all the time or there's a matter of policy, you do have a bit of a logical problem there in terms of injunctive relief going forward, yes. Under our case law, these allegations were insufficient basis to provide a federal court with jurisdiction to entertain count 5 of the complaint, because we're not dealing with stuff that's firm enough. Of course, it may be that among countless encounters between the police and citizens of a great city such as Los Angeles, that there will be certain instances in which strangleholds will be illegally applied to and injured, and death unconsciously inflicted on the victim. It's just interesting to see how our perceptions of things change over time and my own changes of perception because I don't see any problem with this legal rationale on its own terms. But then, of course, knowing what I know now, I know how it actually worked out. Now, that's really interesting just in terms of a whole bunch of things. Like, I have more information than I did in the past. So I can make a different decision now, and I can use O'Connor's rationales for a reason to overturn precedent. But I can't see anything wrong with it in the first place, even though it led to bad things. So it's a very interesting thing where it's like you look at this and you think about the actual legal standards and the legal questions that are applicable, and the what the Supreme Court says here is fully reasonable. It's too speculative. There's things that we can't look to the future. It's just whatever, but it's like another step on the road, and it isn't obvious that any particular step was wrong. It isn't clear that any particular step was incorrect, but we've reached a place where we're now looking at this with renewed eyes, and we're like, okay, there's a problem now. So, it's like it's kind of like no snowflake is responsible for the avalanche kind of thing. I take a look at this and I look at this. I'm like, yeah, I can't see a legal problem with this. But then I look to the situation today and what some of the things the police are doing. I'm like, okay, there might be a legal problem. So it's just interesting how the accumulation of information, particularly as it is informed by body cameras and video cameras and all the rest of it, changes perception. But then, of course, that's changes of facts and changes of rationales that goes to O'Connor's ideas. So, like, I wouldn't necessarily uphold this decision today, but there's nothing wrong with it at the time. Just interesting how that what the future has revealed, I suppose, is all I can really say about that. As we have said, however, it's no more than conjecture to suggest in every instance of a traffic stop, arrest, or other encounter, the police will act unconstitutionally and inflict injury without provocation or legal excuse. Yeah, it's not all of them, but it's enough to be concerning. And we really need to do something on qualified immunity. I think on Monday, I believe on Monday, the Supreme Court has a couple cases up for discussion on whether or not to grant cert dealing with qualified immunity. I really hope they take one of them, man. I really hope they do. And we need to reform qualified immunity. It's the very least we can do to help fix some of these police issues and create some accountability. Lyons fares no better if it's assumed that in his pending damages suit affords him relief to seek an injunction as a remedy for the claims arising out of the offense. The equitable remedy is unavailable absent a showing of irreparable injury, a requirement that cannot be met when there's no showing of any real or immediate threat the plaintiff will be wronged against, a likelihood of substantial or immediate irreparable injury. Nor will the injury that Lyons allegedly suffered for the past choking event go uncompensated. For that injury, he has adequate remedy at law. Again, questionable. See qualified immunity, but okay. Absent a sufficient likelihood that he will again be wronged in a similar way, Lyons is no more entitled to an injunction than any other citizen of Los Angeles. Fair. There's nothing unique about him, so everyone should get it. And a federal court may not entertain a claim by any or all citizens who do no more than assert that certain programs, certain practices of law enforcement are unconstitutional. The judgment of the Court of Appeals is hereby reversed. So that is a relatively short discussion of City of Los Angeles versus Lyons, and it's interesting again to see how legal standards change and perceptions change. I can't see any massive problem with this legal decision in 1982, especially when we talk about injunctions and the standards under which we give them. Injunctions are an equitable remedy, and under the facts of this particular case, I think that this is the correct legal conclusion as far as I can tell. But it's very interesting to see how we feel about it 30 years later, or 40 years later at this point, to be quite honest. So how we feel about 40 years later, particularly in lieu of the footage we have and the evidence that we have that the police, at least sometimes, are behaving in a way that's improper. I think many police behave in a way that is proper, and many police, and then some police don't. And I think there's enough evidence of what we've seen on footage to see the police acting unreasonably, at least in some situations. And so I think that more information has granted us additional light. And I think it is time to reconsider qualified immunity and do something with it. I don't know if it should be abolished or not, but it is definitely something that needs to go because we need a mechanism to keep the police accountable. And I think that would be a mechanism to keep the police accountable. We have a mechanism in law. We just need to remove the constraints. 42 USC 1983 is doing great. Qualified immunity is killing it. And so we need to do something on QI. I don't know exactly what that is. Maybe we need to end qualified immunity altogether. Maybe we just need to force courts to create new law. I don't know. But it's just interesting to see how our perceptions change when we read this case and we're like, yeah, I don't have any major problem with this, but I do have some problems with the cases in gross and how they have led us to a place that is creating problems with police accountability. But that's the end of the coverage of this case.